the top court in its counter arguments. We'll go back to Ananya after we just bring you through the counter arguments. Why abrogation was needed? The first argument was the 2019 Pulwama attack prompted the 370 axing. This was the biggest revelation that said that the biggest thought towards comprehensively removing 370 was the attack in Pulwama. Can't fault change that brings everyone at par. And Article 370 was not meant to be permanent. It was always called a temporary provision and it had got to go. In fact, around the time Pandit Jawaharlal Nehru's demise, at that time the Congress was largely in consensus that 370 had to go, but then it didn't happen. Argument 4. Article 35A was discriminatory to many, and 35A was not even mentioned. It was supposed to be one of the subprints and footnotes in the Constitution, which many in the top court lawyers were not aware when the matter came to be heard in 2014, between 2010 and 2014, that something like this even existed. Argument 5, hindrance to rights projected as pride. So these were some of the aspects which have been counter-argued. Ananya is with us. Ananya, the verdict is expected, what, around 10:30? So you will be going in just a bit. So what can we expect? It will be a one-line verdict, or do you think that there will be a detailed reading done by Justice Chandrachud before the final verdict is pronounced?
Well, definitely, it would be a detailed reading of, the judgment that has been rendered by the Chief Justice of India and the other judges on the bench. Remember that this is a constitution bench matter, so there might be one or two judgments as well. So we'll have to see if at all there are different judgments coming in. The judges would be reading out their own part of the judgment and whether or not they concur or dissent to it. So we'll have to wait and watch for that. But definitely, as you're pointing out the central government's argument, the central government began by saying that under Article 1, Jammu and Kashmir is very well a part of the country. It is very well a part of India, and that's exactly what the central government's pitch has remained. Apart from that, the central government argued that 370 was a temporary provision. It had to go someday or the other, and in fact the Constituent Assembly, when it had introduced Article 370 in the Constitution of India, had in mind that Jammu and Kashmir is a very well a part of India, and that's exactly why there cannot be two constitutions. There cannot be a constitution for Jammu and Kashmir, is what had been argued by the central government. Another and the most important facet that the central government has been pushing for from day one is that this particular exercise that was carried out on August 5, 2019 has resulted in restoration of peace and has given a big tourism hit to the state, to Jammu and Kashmir, and that's exactly why this is a very, very important exercise, and it was a rectification of the mistakes that had happened in the past.
Rectification of a mistake is a valid argument. Peace, progress, vikas, everything is a valid argument going forward. But that act itself, the way, the manner in which it was done, was it in the legal framework that is provided by the Constitution, by the Samvidhan? That's the bigger question. Ananya, you're going in. We'll have Anusha and Arunima joining us. We also have our guest this morning. We have Kapil Madan with us at this point. We'll also have Ashutosh Srivastava, lawyer and political analyst. And we will be also joined by one more of our guests at this point. Farooq Renzusha is not yet with us, but
one
yes,
point on
yes,
this
Rahul.
question that you've been asking about the legality of this. So let me tell you that Harish Salve, when he spoke to me, he said the following. He said that there has been legal precedent when the government substituted, with reference to the Constituent Assembly of the state, to Legislative Assembly of the state.
Yeah.
So on that point about whether the Constituent Assembly, after it is dissolved, things become written in stone, on that point, he actually pointed to a precedent saying that no, other actions had been taken. After the Constituent Assembly was dissolved, to further dilute the provisions of Article 370. What did he say? First time it was done was when Sadar Riyasat was substituted with governor by amending 367. Through the mechanism of Article 371D, the Supreme Court said that absent that, it would have to construe whether the governor is the successor to the Sadar Riyasat. If the president has done it by amending Article 367, that's another way of doing it. That is exactly the problem which had come up. the central government has traced its steps on precedent. So the legal argument is strong, and therefore perhaps why Kapil Sibal is saying, ab jo,
there some
what he has
battles
said.
are fought to be lost.
Yeah.
Now, some of the key questions the Supreme Court will be examining today before we go across to our guests and we get a confirmation of who all are through with us. Some of the key questions are: one, was Article 370 of the Constitution intended to be a permanent provision? First question. Can the President abrogate the special status of Jammu and Kashmir under Article 370 without the assent of the Legislative Assembly of J&K? That's the one. Because the Legislative Parliament, the Assembly had been dissolved. It was under central rule or the Lieutenant Governor's rule at that time. Was reorganization of J&K in two UTs, Union Territories, tenable? That's another part of another petition. Would Jammu and Kashmir retain its sovereignty since it signed the instrument of accession and not a merger agreement? And since Legislative Assembly had been dissolved at the time, can Parliament or the Governor be a substitute for the same? So these are some of the questions that need to be answered. We'll